Mr. Powers? Thank you.
Thank you.
You may proceed.
May it please the Court. My name is Kevin Powers, my associate Rob Nantel, and we represent the plaintiff in this case. In 1986, Hiram Clifton became the first African-American foreman in the MBTA's Engineering and Maintenance Department. This case is about the 9 years of discrimination, harassment, and retaliation that Mr. Clifton endured, and the 10 years of litigation so far he has gone through. We are here to ask this Court to end that saga of 19 years and to finally put an end to this case and decide that the jury was correct and uphold the jury's award of damages, both compensatory and punitives, the punitives as being appropriate. I also want to stress to this Court that given the 10 years of litigation and the 5 years since the trial, my client is in a position now that he will accept a remitter if one is judged by this Court to be appropriate. Of course, we allege that the remitter granted by the trial court was not appropriate.
Well, that presumably, while that is helpful, Mr. Powers, that presumably is, you ask us to consider all of the issues and then what your client and the MBTA do thereafter. I mean, you're not asking us not to consider the remitter issue.
Absolutely not, Your Honor.
So why don't we just proceed? We'll consider whatever issues are raised, and then what happens thereafter happens thereafter.
Okay. Your Honor, this case, as I said, in 1986, Mr. Clifton was appointed as the foreperson in the Engineering and Maintenance Department. And during the 9 years that this case is about, and by the way, Mr. Clifton continued to work and continues to work at the MBTA. This case is a snapshot of 1986 to 1995, 1995 being the date that we filed the Superior Court complaint.
Mr. Powers, forgive me for interrupting you. Could you explain to me, the jury verdict was entered when?
1995, September of 1995.
And I take it a notice of appeal was filed?
Yes, it was.
And why are we now a decade later?
Wait a minute. The trial was
I'm
when?
sorry. The trial was tried in 1999, I'm sorry.
Okay.
And so the jury verdict, the verdict was when?
1999.
And then when was the, what was the delay?
Well, the appeal was filed, and I assume that the delay was in part due to acquiring the transcript. It was a 3-week trial. I have had that problem in other cases. Of course, I wasn't the appellant.
Okay.
But it appears that there was a delay in the transcript.
Of several years.
Of several years, yes. And so in summarizing the facts that were presented to the jury in this case, Mr. Clifton was subjected to various kinds of harassment. They consisted of verbal threats, verbal insults, such as calling him a nigger lover, Sanford and Son, dumb fuck, and other racist-tinged statements. They consisted of actions taken against Mr. Clifton, such as shooting bottle rockets at him, throwing water balloons at him, distributing, by his supervisor, distributing a picture of a black woman with a notation asking for sex, and with Mr. Clifton's cell phone number on that document.
I think it's quite clear that the facts are egregious and the jury so found. The questions really relate to how the statute is intended to operate and whether or not there is and how the continuing violation rule would apply in these circumstances, and whether or not the instruction was proper on this subject. So why don't you turn to that? Why wasn't, or was the instruction proper? Why wasn't it incorrect? Has the MBTA preserved this issue for us?
Yes. I think you're asking about, number one, the discrimination case and whether the jury should have been told about a hopelessness standard. Of course, the Kadaya case had not been decided in 1999. So the court did not know about the hopelessness standard. We contend that that was a standard that was not foreshadowed by any of the cases.
Can I ask you this question? Because as I read through this, I was struck by a very basic problem. Case was filed in the Superior Court in 1995.
Correct.
Clearly, Mr. Clifton was the subject of harassment long before that, and indeed, in 1990, 1991, and 1992, had filed complaints with the affirmative action officer in the MBTA. Isn't that correct?
That's correct.
There's a 3-year statute of limitations with respect to this cause of action. Why, if the action was filed in 1995, did it extend back to 1986?
Because the judge applied the continuing violation theory. The argument is that the continuing violation theory does not simply apply to the 6-month or 300-day now statute of limitations for filing with the MCAD, but should apply to the filing of the complaint. So if you file the complaint and there's a continuing pattern and there's actions within the anchoring period, then the entire cause of action or course of action should be considered by the trial jury, and that's in fact what the judge did. And that's, by the way, we do not know for a fact that the jury, in awarding the damages, both compensatory and punitive, considered the continuing violation theory. It is quite possible that they simply considered the 3 years from the filing date. And the defendants in this case did not ask for any kind of limiting instruction on that, and they didn't ask for any clarification.
Mr. Powers, you made reference to the anchoring period, and I'm wondering if you can help me out, because as I understand it, there's the date of April 20th, 1993, and which is what you folks addressed during the trial, and then the appeals court used a different date for the anchoring date of August 22nd, 1993. Can you talk about that and explain that?
Yes. And we have to clarify the anchoring period in the discrimination case and the anchoring period in the retaliation case. The April 20th, 1993 date was the start of the anchoring period that the judge told the jury they could consider. So the anchoring period under the retaliation claim was from April 20th, 93 to May of 1995, that being 95 being the time of filing. Now, what we also have to understand is that that statement and that use of the anchoring period and the fact that the continuing violation theory was applied to the retaliation claim was never challenged by the defendants. If you look at the jury charge conference or the objections at the end of the jury instructions, the defendants accepted the continuing violation theory as applying to the retaliation claim. As a matter of fact,
and the judge, as I understand it, was quite clear that for the retaliation claim, he specifically identified April the 20th, 1993 as the anchoring date?
yes.
Okay.
Yes. Not only did he identify it, but if you look at Appendix 72, 73, and 74, and that is the defendants proposed special questions to the jury. The defendants proposed that very date as the beginning of the anchoring period, and that's on Appendix 74. The question the defendants suggested to be asked to the jury is, has the plaintiff proven by a preponderance of the evidence that he suffered an adverse employment action after April 20th, 1993. During the charge conference, we were arguing for an earlier anchoring period.
On the retaliation
On the
claim.
retaliation claim,
Okay,
yes.
okay.
The defendants were arguing for April 20th.
Okay.
The defendants won that argument, and the jury adopted their date. And now, not contesting that, only at the appeals level did the defendants raise that as an appellate issue. And it's our position that they're foreclosed from doing that. They did not raise it at the trial level, and in fact, they provided the date and suggested the date, and they shouldn't be allowed at this time to say, oh, by the way, the date that we asked the court to use, we think is now wrong.
Well, if you're right, then there's no need for a new trial on the question of liability or compensatory damages.
No, that's correct. I don't think there is a...
Then we can go straight to the punitive damages issue, correct?
I'd rather consider punitive damages.
No, I'm not telling you to go
Yes.
there, but I mean, if
And
you're...
I take it, Mr. Powers, that there are two issues. One is can that issue be submitted to the jury? And second is, should there be a remitter, correct? Haven't they raised whether or not punitives are a jury question?
No, the
Okay.
defendants never raised the issue whether punitives were a jury question.
Okay.
Yeah, frankly, I'm astounded that it's not astounded, but I'm a little bit surprised that the appeals court got into all this stuff because Cudger hadn't been decided. As you just pointed out, the date was the one the defendant wanted. The instructions seemed to be in accord with then existing federal law. And so what's the deal?
Well, what it seemed to be is the appeals court was basically saying, well, those were issues, but we really don't think those would cause us to remand this case for a new trial. But because the plaintiff refused to accept the remitter, it's going to have to be retried anyway. So why not retry the whole thing? And
Well,
my argument is
If we decide the remitter is that the appeals court and the judge were wrong, then we're back to square one, that the other issues don't amount to anything.
That's correct, Your Honor.
Could I
That
just
is
make sure I understand your theory of and maybe I misunderstood this from your brief. What I'm hearing from you today is to say the specific date, the April 2093 date, is in defendant's own proposed special questions.
Yes.
And they didn't object to the jury instruction.
And there was no objection to the use of that date. In fact, plaintiff had been asking for an even earlier date. So that, but when I read your brief, I thought it was about what's the instruction on this subject. My understanding was that the defendant had been asking for an instruction along the federal standard, the then existing, still existing, I guess, federal standard, and that Judge Gantz pointed out to them quite accurately, number one, the SJC hasn't spoken on the issue yet, and then gave his prediction, which has turned out to be accurate. I don't think the SJC is going to adopt the exact same standard as the federal. And that
They then did not
and
object.
they then did not ask for they didn't say, well, preserve our rights about federal, but we want something, they didn't make an attempt, in other words. So he didn't instruct on the federal standard. But what did he instruct on? I mean, maybe a simple question. I thought you were saying waiver because they didn't object to the instruction. What I'm hearing today is waiver because they'd already agreed to a specific date in their own proposal?
Yes, in the retaliation. In the retaliation claim, they proposed the date that was adopted by the court. The argument during the charge conference was whether the court should use the federal standard, the revelatory standard.
On which?
On the continuing violation.
No, I understand. But on discrimination or retaliation?
Well, they didn't make that clear.
Okay.
So we don't know. But their argument was...
saying, I don't mean to interrupt you, but
Sure.
you're saying it's irrelevant because if we simply look at the retaliation, that's sufficient, correct?
Yes, that is sufficient, because the jury awarded damages on the retaliation claim.
Don't worry about the yellow light. Could you go to the remitter question?
Yes, Your Honor. First, you have to understand that Judge Gantz specifically found that the jury verdict was not the product of any bias, misapprehension, or prejudice on the part of the jury. he in fact found that they exercised reasonable judgment in their verdict. Judge Gantz, in his decision, specifically also found that the actions of the MBTA were reprehensible. What Judge Gantz had a problem with was the amount being excessive, $500,000.
$5 million.
$5 million, I'm sorry.
The punitive damages was $5 million.
Yes,
The compensatory was $500,000.
Yes, and he therefore reduced the $5 million to $500,000. The main argument Judge Gantz seems to make is that the punitive damages are inappropriate in that amount against a public entity. There is no support in the statute for holding public entities at a lesser standard.
But why isn't that a consideration? Why isn't that, even though it's not in the statute, why isn't that an appropriate consideration?
Because I think Judge Gantz had it absolutely wrong. He was saying that if that kind of punitive damage award of $5 million might be appropriate against a private entity, but not a public entity. And I would say that a public entity, to engage in the type of actions that they engaged in the Clifton case.
Then the taxpayers really ought to be punished.
Well,
I mean,
yes.
This is all back on the taxpayers.
Well,
it's not back on private corporate stockholders who could influence the
Well, the MBTA
course
is
of
a body politic and
that's the
corporate,
point,
so-
Your Honor. Because if the purpose of punitive damages is to punish, number one, and to make sure or to try to assure that this type of action won't happen again, the best way to do it against a public entity like the MBTA is to sting them with an amount such as $5 million, because it's only then will the politicians and the taxpayers take heed of the actions that they are engaging in.
Mr. Powers, these are very interesting arguments, but just as a matter of law, correct? The MBTA is a body politic and corporate,
Yes.
correct? So it's
which
not,
receives what, $500 million state subsidy?
No, many of these do.
$195 million a year.
Here's my
Plus capital.
Here's my question. Whenever any entity waives sovereign immunity, which has happened in this case, presumably one can put any limitations on it. One can say, for example,
Yes.
no punitive damages. In other words, there may be public policy arguments one way, there may be public policy arguments another way. It might be, for example, at the judge to say, well, this is a private entity, but there are a lot of little shareholders who've invested and, you know, they haven't had a return on their investment for some time. The question is, as a matter of law, to what extent is it appropriate in light of the judge's finding to say, but as a matter of public policy, I would impose a limitation on punitive damages that the jury, taxpayers, want to assess against a public entity?
Well, I don't think the judge should be making those policy decisions in light of the fact that the legislature has not put a cap on punitive damages and has not...
Which it has done, for example, in other areas.
That's correct, it has. And the other point is, and I'm asking this Court to formulate a decision, that the lowest or the lowest amount that a judge may reduce it to, punitive damage, is triple damages. The reason for that is if you look at other statutes, and that's one of the things that Labonte and the BMW case say, we should look at comparable statutes and how they punish. If you look at the comparable statutes, you have 151B age claims that require, upon a finding of willfulness, at least double damages and up to triple damages.
But your argument can be turned around exactly the other way and say if the legislature imposed those limits in other instances and they didn't impose them here, then they purposely didn't impose them here. They knew how to do it and they didn't do it here.
Well, I would say that the legislature, in imposing a a ceiling and a floor in the age claim, but didn't do that in other forms of discrimination, such as race, they are saying that we will not have a ceiling of 3 times in race cases.
In his jury instructions, did the judge, his jury instructions on punitive damages, did the judge tell the jury that they could consider something along the lines of what we've been talking about, that this was a public entity and they could take that into consideration.
No, he didn't inform them.
Did they ask for such an instruction?
No, they did not ask for such an instruction.
Mr. Powers, let me ask you this. Let us assume that we do not agree with you on that is to say that we reach some decision that if it's not the $5 million, it can't be any less than 3 times or whatever it is. Could you just tell me why we don't have to have a trial on the whole case again?
Well, my client would accept the remitter, whatever it is that this court feels is appropriate.
Okay,
but in addition to that, the issue of liability is completely different than the issue of punitive damages.
So at least in theory, one could go to a jury and say, this is what another jury has found, boom, 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 boom. Of course, there wouldn't really be an agreement of textual facts because we don't have, this is not a bench trial, so you don't have the judge making findings of fact that are all carefully written out.
And it also would be unfair to the defendant to have to go through the whole process of proving discrimination and harassment when he has already done that.
To the plaintiff, you mean?
Please?
To the plaintiff.
To the plaintiff, I'm sorry.
Yeah.
But don't punitive damages depend so much on the whole context?
Yes, but a punitive damage trial would be a lot more, or a lot shorter than this trial. This was a 3-week trial. I don't think to try punitive damages would have to be a 3-week trial.
And in any event, presumably, there would be lots of issues about whether or not evidence that is now introduced by either side was or wasn't at the first trial, and so how can you, and so on and so forth. Okay.
Right. Thank you very much, Your Honor.
Thank you, Mr. Powers. Mr. Foster.
Good morning, and may it please the Court. I'm Walter Foster, representing the appellant, the MBTA, in this matter. I'd like to go directly to the major question that the panel has presented, and that regards the date of the anchoring event of the retaliation claim. On page 15 of the MBTA's brief, we presented a chart which was very informative and a helpful visual aid to understand the various states that I'm going to be referring to. Not only did the MBTA object to the date of April 20th, 1993, which is the first date that the MCAD race hostile environment claim was filed at the MCAD, but it preserved that objection post-charge. On page 32 of the MBTA's brief, we describe the kind of lengthy, of course, organic process that any trial goes through in which there are 3 separate days of the charging conference. The MBTA preserved its objections to the anchoring period time frame found at the administrative record, the record at 2664 to 2666. And as that, the MBTA registered 10 separate objections, 4 of which pertain to both the preservation of a continuing violation instruction on the race-based claim and the limitation of damages, as well as to the limitation of the continuing violation claim and the limitation of damages to the retaliation.
Mr. Foster.
Yes, Your Honor.
Did the MBTA use the April 20th date in Section 2, question number 2 of its proposed special questions for the jury?
Your Honor, as you can see, that is exactly the date that we submitted at the very onset of trial. The judge in this case had asked that at the beginning of the trial. During the pendency of this trial and throughout as the trial developed, and more particularly from the beginning of the charging conference, the MBTA amended that, if you will, statement or representation to the court and asked that damages and an anchoring event be found only by August 22nd of 1993, which is the 6th month prior to the second MCAD retaliation complaint being filed. At the heart of this case, and the core of this case, both in the motions in limine, through the way the case was developed throughout the entire trial, and specifically as represented in the charging conference, the time of accrual of both an underlying race claim and the retaliation claim was at the heart of the case, given the status of the law. Of course, this was pre-Kadir, and so what the parties had.
Even long prior to Kadir, I mean, part of this goes under the category of no good deed goes unpunished. It seems to me that if Mr. Clifton had not filed a second charge, he could have included his retaliation claim merely by amending his complaint, and it clearly would have dated back to the April 20, 1993 date. The only reason you're arguing for this August date is because he gave your client the benefit of filing a separate charge for retaliation, thereby giving your client more notice, the administrative proceedings, et cetera, that many defendants don't get on retaliation claims. I mean, it really does seem to be penalizing or attempting to penalize the plaintiff when the plaintiff did more than the law required of him.
Your Honor, both what the facts represented is that the complaint filed a year later, correct, a year later for the retaliation claim, was that on the record at page 241 is the first 1993 complaint. All that needed to be done is there's a series of boxes. There's one box checked off for race. There's a box right there for retaliation. There's 5 sentences to this complaint. If the plaintiff was aware and for purposes of both investigation, conciliation, as identified under Ocean Spray, that underscores the issue of both notice and that support an independent claim in the statute, all that needed to have been done for it to either relate back is to put the MBT on notice. That didn't happen.
But that would have been with regard to retaliation occurring prior to the administrative filing. The more common retaliation claim that we see, and I gather it was in this case as well, is a claim that there was retaliation for the MCAD filing, correct?
Your Honor, yes.
Yeah, okay. And that's the kind of retaliation claim for which one does not need to file a new charge or even an amended charge. You can just amend your complaint.
Your Honor, I think both
and you can amend your complaint?
Almost any time.
Absolutely.
Well,
absolutely.
Recently, we permitted an amendment that was weeks before trial, if not days before trial, after years of litigation.
So why, I mean, and I take it, why is the April 20, 1993 date, which clearly would have been the date, I think clearly would have been the date if he had not filed any later charge, why doesn't he get the benefit of that date? It seems to me odd to take it away from him because he went the extra mile of filing an updated new charge.
Your Honor, originally during the charging conference, the Court had adopted the MBTA's position that you could only anchor in order for the continuing violation to apply. And at least let's not forget the context of this was without the benefit of Kadir. All of the able counsel in the trial court was trying to determine how to both distinguish and present this to the jury in some comprehensible way. And in this case, we had the tension between an actually filed retaliation complaint, and the Court specifically asked the plaintiff.
That's the April 22nd? I mean, the February 22nd.
The February of 1994. And the dialogue between the Court and all parties was, how do you deal with this? And what the Court ended up doing, after literally reversing at least on 2 occasions over a 3-day period, is treating it as if the 1994 complaint never existed. When the plaintiff was asked on the record, what is the retaliatory conduct? In 4 places on this record, the Court, during the charging conference, of course, said that you're only seeking retaliatory acts for those supervisory discrete acts. The type of case was completely different, if you will, from the Noviello type case, which was a retaliation claim based on filing of sex harassment by coworkers. Both the tenor and tone of this case on the retaliation claim was substantively, distinctively different from the underlying race claim. And so the Court asked, what events are you looking for? And what's identified on the record is the reorganization in 1994 where the temporary position of Mr. Clifton, that being what's called a temporary change general foreman, was eliminated. That was the event that was talked about. There was a discipline that occurred in 1993. Again, typical of the post-filing of an MCAD or an EEOC complaint. This fits the rubric. Plaintiff argued that there was a myriad of other type of retaliatory conduct which the trial court judge did not agree with.
But assuming that you are correct, let's assume that there's only one. Let's just take a simple thing, which is the reorganization. Again, to go to Justice Sussman's point, that happened, whatever the date, let's say January 1994. I don't know when it happened. But so a new complaint is filed with the MCAD on February the 22nd, 1994. In any other circumstance, the plaintiff would have been permitted to amend its complaint, his complaint.
Or just included in the complaint.
Or just included in the complaint,
Right.
and
Without a new charge.
the jury, that you then introduce whatever facts you want to introduce. Correct? So if you look to the anchoring period, it may have been that they are, I mean, frankly, job loss, which I take this was, correct, or job elimination.
Your Honor, it's actually where he kept his rated job rating. It's obviously a union-based environment. So he had a job as a particular level and was temporary into the next position when that was available.
Okay.
So that became unavailable.
But typically, when there's that kind of employer action, valid or invalid, I'm not making a judgment of that, as opposed to just, you better watch out now that you filed a complaint, you're never going to be promoted. But where you actually have an elimination, it's not unusual for a plaintiff to focus on that, but that doesn't answer the relate back question.
Yes, Your Honor. As the Court struggled to apply these, I think that what it settled on was really what the Supreme Court has enunciated in the Morgan case through Justice Thomas's opinion, that in retaliation claims or in the hostile environment setting, there's a distinction between both the discrete acts and the non-discrete acts. And this begets the question of whether or not a continuing violation would even apply to a retaliation claim. And in this kind of a case where there are discrete acts, and given the history of this case, which was the prior conduct, the MBTA consistently both preserved and argued that given those discrete acts as compared to the particular paradigm of which a continuing violation generally applies, which is the individual has not yet either appreciated their position so that a reasonable person would file a complaint. And that was the major distinction that I think the judge was trying to give credence to.
Right, but we're still, it seems to me, certainly once the original MCAD charge is filed, then whether they are discrete acts or not, the point is that the plaintiff is not under any obligation to file another charge about it. So you don't worry about timeliness or continuing violations or Cudyer or any of these complexities once you're into that time frame. Now, you may worry about them if you're talking about prior retaliation, prior to the original charge that was retaliation for the internal complaints and that sort of thing. That's a different environment. But once the original MCAD charge has been filed, the concept of timeliness of a charge for retaliation is kind of it's a unicorn. It's a figment of our, intellectual imagination, but it doesn't actually exist because it just doesn't come up.
I understand, Your Honor. There are two is the cases that are cited in my brother's brief, both Carter and Edwin. Those were amendments of cases, and what the MBTA would urge this Court to adopt is really the core, if you will, spirit of the Noviello case, which is there's a distinct and separate animus, as well as the type of claims that apply. It's an independent cause of action, and therefore notice should apply.
The difficulty that I have with that, and particularly with respect, and I'll go back and look at Noviello, but the difficulty that I have with that is that the legislature has been very clear that it's particularly concerned that if people assert their legal rights or make a claim of discrimination, that they not be penalized by their employer as a consequence of that. And so it seems to me that the legislature has suggested, whether one wants to call it a continuing violation in the sort of classic sense that that you don't have to file your complaint. What the legislature is really saying, we're now in one employment relationship and we're in a very sensitive period, because one thing we know is that employers, understandably, resist when they don't believe there's any merit to it. And the legislature have said, we're just going to essentially say that this is a safe zone for employees. And your theory of look at it as something very separate from and discrete and therefore calculate, statutes of limitations and all kinds of other things seems to me to undermine what the legislature has told us. No, you really have to view this as a continuation of the original, not the original underlying acts, but of the April 20, 1993 date. That's when this stuff started.
I understand, Your Honor, and there is at least, of course, the policy underlying the whole MCAD statute and the short statute of limitations, which is really, in a sense, the tension that is created here, is meant to allow, in an informal process, both employers and employees to try to work out their differences through an investigation and conciliation process. And that's why, now extended to 10 months, it's probably one of the shortest statute of limitations, period. So there is a tension, even within the legislative structure itself, as to that argument. But I'd like to address, if I may, there are separate and independent grounds for this Court to find that a new trial on liability must occur, and that was the MBTA's objection and preservation as to the continuing violation doctrine to the race-based claim. And basically that, again, was preserved post-trial, post-charge to the jury at the same pages that I've cited and rely upon in my brief at 2,666. The T specifically objected on 2 grounds, and the Court had instructed the parties that they may incorporate their arguments from the charging conference by reference and need not repeat them verbatim. And that's exactly what the MBTA did. As it applies to the continuing violation, there was an extensive discussion and presentation of the Preventure standard, which had been adopted by at least 3 Superior Court decisions of very able judges within on the state side. There had been no guidance from this Court as to that. And so there's a colloquy that I want to point the Court towards on pages 2,337 and 38 that directly goes to the heart of what you might consider the Kadir formulation standard. First, the MBTA, of course, made and preserved its right under the Preventure standard, the known or should have known. And this has become at least, arguably, the first part of the Kadir now formulated standard. Secondly, insofar as Kadir is distinguished from the standard, the Preventure standard, the concept that a reasonable person armed with the plaintiff's knowledge would have filed a claim was part of the MBTA's argument during the charge conference, and as such, sufficiently brought within the preservation rubric its objection post-charge to the jury. At 2,320 of the record, the MBTA argued that the concept of a reasonable person must be imported into that hostile environment claim. And the T sought to import the objective standard, which implicitly and discussed the plaintiff's knowledge and appreciation of their environment. During the charging conference, the MBTA suggested that the Court actually used the term defining as part of a descriptor of the hostile environment beyond the pervasive and so sufficiently pervasive and severe description, which of course is in our case law. The Court accepted that definition, and that, to me, is the heart and captures basically the benefit of what became the Kadir standard. And I'd also like to address this Court's concern, because it was a concern for all the parties, was the delay within the time frame, because this case itself could have been the Kadir vehicle. And as such, but for a 2.5-year delay for trial transcripts to be transcribed in this day and age, this case, which filed for direct appellate review, was not accepted by this Court in 2002 before Kadir was even decided. And so it is very possible, if not probable, that the 2-year hiatus through the appeals court would have come to this Court within a timely manner.
But the issue would still have been whether, having asked, correct me if I'm wrong.
Yes, Your Honor.
You asked Judge Gantz to give an instruction that accorded with federal law at the time.
Correct, Your Honor.
Judge Gantz, it seems to me, told you 2 things, both of which were accurate. 1, the SJC has not decided whether to adopt that standard. Therefore, you're asking me to do something that is not yet a matter of Massachusetts law, and he had concerns about that. And the second thing he did, which was also accurate, was he accurately predicted that he did not think that the SJC, when it got around to deciding the issue, was going to adopt the federal standard in its entirety. So he sort of warned you, sort of there's no law, there's no SJC law on the subject, and I don't think that's where the SJC is going to go. And I take it that at that point, you were still asking him to use the prevention standard. And you did not, it seems to me, follow up on his invitation. Do you want to give me sort of a compromise? You could have preserved your rights about, well, we really think you should, instruct in using the language from the First Circuit, but if you're not going to do that, Judge, please, we'll
at least
try this slightly watered-down, compromised version that maybe is a little closer to what the SJC is going to. I get the impression, I understand it's difficult, but that you didn't try to do that. You didn't give Judge Gantz anything other than prevention.
Your Honor, I don't think that accurately represents the record at this case. And as stated, and I rely upon the citations in my brief, but what the MBTA did at that point in time was use the Desrosiers case and the other cases to discuss specifically what type of tolling events would allow a continuing violation. We discussed specifically what I refer to colloquially as the bookend argument. The continuing violation really just addressed, do you get to encompass time or incidents that precede the 6-month filing deadline? But it never addressed, and this is what the MBTA sought.
But what did you ask him for an instruction?
Your Honor, we asked him for an instruction under the Desrosiers case and the others about the tension in those cases, and again, this is at 2,337 and 38, some type of verbiage that would instruct that if it wasn't a tolling event, that being the person was intimidated or they were physically threatened not to file, that a reasonable person would have then brought forth that claim. The exact colloquy between the court and myself, as I recall it, and is found on those pages, is informed by the dialogue that was ongoing about when that statute of limitations. It all comes down to the trial chalk that was drafted.
Mr. Foster, I don't wish to interrupt you. Did you suggest to the judge that a reasonable person, leaving aside the threats not to file and something, would have filed by when?
Your Honor, we argued no later than 1988 or 1990.
Okay.
There were multiple events that we picked, and the earliest one that we picked and identified for the court is that no later by 1988, a reasonable plaintiff with, this is the time period, and the distinction here on the facts of the case, was that the very earlier period were taking all statements by the plaintiff as true, was very reprehensible and very clear. Absolutely outright.
When was he temporarily promoted?
That reorganization occurred in 1994. So that is substantially after the time. He was promoted in 1986 to the position of foreperson down at the Charlestown Yard. That was his promotion. And it was by Mr. Rooney, who's the individual who's named in the MCAD complaint as being retaliatory against him. But the time period that we identified based on the facts of the case, when a reasonable person, he had alleged daily occurrences of racial slurs, he had alleged physical issues that were described earlier. And then in 1988, he makes the statement that I have to get out of here, this being this work environment at the Charlestown Yard, and it transfers to a different work site for 3 years. So the T had tried to raise the argument of both of hiatus and causal nexus on a temporal basis, had been abrogated. And so we posited to the court that at least by 1988, when the plaintiff himself reasonably, and in fact was subjectively aware that things weren't going to improve, he removed himself, again, taking all as an argument in the alternative. And then by 90, he filed at the EEO, the internal EEO. So any one of those triggerings would have also triggered the knowledge. This was not one of those cases where you're trying to fill an empty gap in the middle. So we had identified 1988 and at the latest of 1990 when it should have been brought.
Okay. Your time is up.
Yes,
you want to say two quick things on remitter?
Yes, Your Honor. My argument on the remitter is in very summary fashion is that the standard here is the abuse of discretion, which there has been no evidence, at least marshaled, that somehow the trial court judge who is most familiar with this case and I think carefully weighed and certainly had the ability and foresight about potentially even where the continuing violation might go, weighed very carefully those issues and factors and exercised his discretion. There are two parts both in the record that support that. It's in his decision. Of course, there were no measurable or appreciable economic damages. That was the case. And so what he did is he permitted and did not remit any of the compensatory damages at $500,000. What he did was lower what was then the $5 million down to what effectively became a 1-to-1 ratio. And I understand we often end up talking about ratios, but certainly that is not the structure, and it's not a criteria for decision of the trial court's discretion, which we say was adequately and well within those bounds.
Thank you.
Thank you,
Thank
Mr.
you, Your Honor.
Foster.